So what role does mediation and arbitration play in resolving construction disputes, and when should it be considered?
So almost all contracts have or should have a dispute resolution term. If you don't have that, I would say it's a quite significant oversight, because you are essentially left with pursuing your debt or dispute via the public courts. We've had an unfortunate development in BC, and I think Canada-wide, just with the shortage of judges.
Yes.
And our legal system is it's clogged. Like, we can't get in front of judges on time. We can't often reserve enough courtroom time to be heard. A lot of these trials require 10, 15, 20, 30 days of trial time. Trials will book 2, 3, 4 years out, and then oftentimes get pushed because certain judges are moving, or there's less judges, or they can't find replacement judges.
Yeah.
So what we've seen is a significant uptick in alternative dispute resolution, which means private mediation or private arbitration. So mediation is non-binding. You generally find a mediator who's most often an ex-judge or a very well-respected senior ex-lawyer in the industry. And you will schedule a mediation with the other counterparty, and you will meet and discuss your disputes and your side of the story. And you usually prepare mediation reports. So you set out your facts and your view of the law. And you present this in front of a mediator who's an objective third party. And the mediator will jointly generally listen to a session of mediation and then break out the groups into breakout rooms and try to coach them along and introduce for them the potential risks if they were to go to litigation, the downsides, the costs, the stress involved in litigation. And oftentimes they end up settling or settle shortly after a mediation.
Yes.
The problem is the mediator has no authority to make a binding finding on the parties. So if you don't settle, that's it. You pay your mediator bill. It's private, and you move along.